Everyone, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Nazha binti Mazlan, B student ID 0595558. In this video, I will be explaining about the historical background of family law for non-Muslim in Malaysia. There are going to be 3 main points that I want to highlight in this video. The first main point that I want to explain is about the law that governs family matter of Muslim and non-Muslim in Malaysia. For Muslim, the law that governs matter related to Muslim family is Islamic Family Law Act 1984. This act provided matters related to marriage age, marriage registration, polygamy, obedience or maintenance, talak, judicial divorce, post-divorce maintenance or financial agreements, and child custody and guardianship. On the contrary, the law that governs matter relating to non-Muslim family is the Law Reform Act 1976. This act recognizes monogamous marriage and it is applicable to non-Muslim in Malaysia and those domiciled in Malaysia but resident outside Malaysia. This act is not applicable to any native of Sabah and Sarawak. Now moving on to the second main point, which is the historical development of family law for non-Muslim. This historical development are divided into 3 parts. The first part is the historical development of family law for non-Muslim in Peninsular Malaysia. There are 4 types of marriage and the first one is common law marriage. These type of marriage are not done according to customary law or statutory law but recognized by English common law. There are 2 requirements that need to be fulfilled, which are cohabiting for a period of time and repute of marriage. The second type of marriage is customary marriage. These marriage are divided into 2, which are Chinese customary marriage and also Hindu customary marriage. Under Chinese customary marriage, it recognizes polygamous marriage and there are 3 ways to prove the marriage, which are long continuous cohabitation, intention to form a permanent union, and repeat of marriage. The intention to take the woman as his wife must be distinguished. Under Hindu customary marriage, the marriage is mainly polygamous. Appropriate ceremonies need to be performed as defect in ritual might result to avoid marriage. The marriage of Ceylon Tamils had been monogamous. In Hindu customary law, the marriage need not to be registered because there is no minimum age and validity depends on essential item on ceremony. In order to identify a valid marriage, the court accept evidence from priest and expert evidence of Hindu custom. The third type of marriage is native marriage and the fourth one is statutory marriage. Under statutory marriage, the marriage must be performed according to a specific law established before the introduction of Law Reform Act 1976. For the second part of historical development is historical development of family law for non-Muslim in Sarawak. There are 3 types of marriage, which are Chinese marriage, native marriage, and church and civil marriage. For Chinese marriage, it recognized as valid through Chinese Marriage Ordinance 1933. The marriage required to be registered within 1 month and failure to register is a criminal offence. Chinese Marriage Ordinance 1933 established a principle that no Chinese marriage valid unless female is 15 years old by English computation. Under native marriage, it does not include Muslim and it is legally recognized in Sarawak. For church and civil marriage, the law governed is Church and Civil Marriage Ordinance 1958. It is voluntary union for life or until marriage is dissolved by a court or competent jurisdiction. However, this Church and Civil Marriage Ordinance 1958 did not apply to Muslim, Hindu, Dayaks and other that governed by their own law or custom. The requirement for church and civil marriage is age, consent of parent, guardian, kindred and affinity, no prior subsisting marriage, consent of parties, procedure and formalities. Moving on to the third part of historical development, which is historical development of family law for non-Muslim in Sabah. There are 2 types of marriage, which are customary marriage and Christian marriage. For customary marriage, the law that governs it is Sabah Marriage Ordinance 1959. For Christian marriage, the law that governs it is Sabah Christian Marriage Ordinance. The marriage must be solemnized and registered as the failure to do so will result in null and void marriage. There are few requirements that need to be fulfilled under this marriage, which are age, consent of parent and guardian, kindred, affinity, and the last, avoidance of marriage by prior subsisting marriage and consent of party. The third and last main point is the difference between customary marriage and statutory marriage. For the customary marriage, the marriage is dependent on the custom, which is Hindu customary law and Chinese customary law, while statutory marriage referred to marriage performed according to a specific law established before the introduction of Law Reform Act 1976. That is all from me. Thank you.